chapter 26 on employment, and this is traditional employment concepts. The very first concept they talk about is the flip side of wrongful hiring or retention, which is wrongful termination. So you get hit from both sides. You hired the wrong people, now you fired the wrong person, and you're going to pay for that. And we're going to touch on this from several different standpoints. But one of the things we want to emphasize is most of the United States is covered by employment at will. What we want to do is we want to emphasize the difference between two popularly confused concepts. One of them is employment at will. Employment at will is a concept from the post-feudal period. Remember with the knights and the kings and all that stuff over in England? What was happening there is, and this includes France and the other major feudal powers like Germany, is we don't really think of this in the essence the way it was. So you were in England, you work on a kingdom. And remember, it wasn't just the king. Each area had its own king or its own ruler, and then they would collectively then pick out somebody to be the supreme ruler, again, for convenience, usually protect themselves against another whole country or tribe. So it's a little bit different than we see in, today's, like, oh, it's the king. Yeah, but back then there were multiple kingdoms under the leadership of a head person, and the deal was very straightforward. It was protection. So you lived on the land. If the bad guys showed up, you would run into the castle. They pull the moat, the big drawbridge up over the moat. Most people couldn't swim back then. That's why moats were considered good security. And plus, what we don't notice is that the moats were not just filled with water. What do you think was in the moat? Waste. Yes, and what else? Crocodiles. Well, not crocodiles, not in England. It'd be a little too cold for crocodile alligators. But probably rats and, but dead animals and garbage and human sewage. So not only did the people not swim, but they really wouldn't have gone swimming in that moat. But in any event, the idea was they the bad guys show up, the Huns come over the mountain and they're heading for your shop. Everybody grab the kids and the sheep and maybe your wife and run inside the castle. Well, she's fast, she can run on her own. So anyway, everybody runs inside the castle, put the drawbridge up, they run up along the top parapets there and they shoot arrows down and dump hot oil on the bad guys or whatever. So this worked for a long time. Now, here's the drawback to that. This is why employment at will developed. You were not free to leave. So say you were a blacksmith, and you were the king's blacksmith. So you weren't free to say, king, I've enjoyed this gig for a while, but I'm going to move my family down to a little village down the hill there, and I'm going to set up my own blacksmith shop. Not your option. You belong to the king. Provided security for you. Also, king drives in and says, I feel like having some mutton today. I'll have that sheep over there. You don't get to say, oh, well, that's my sheep. I'm kind of holding it for Easter dinner. It doesn't work that way. So people don't realize what was the nature of the relationship. So in any event, the bad guys got better at things called cannons and gunpowder and things like that. And castles stopped being the great protection that they were for a reasonable period of time, a couple hundred years in feudal history. So once the castle no longer maintained the significant barrier to invasion and to having the children and the wife scooped up and taken to another town along with the animals, the king didn't have so much say-so. And so the concept of employment at will comes out of what we call the post-feudal period, that you actually had the freedom to leave because your compact between you and the king or the landowner had basically evaporated. And plus, coincidentally, we then run into the Industrial Revolution, which starts about 1776, times in with the publication of Adam Smith's book, The Wealth of Nations. Now, a lot of people use that as the benchmark for the Industrial Revolution in England, which could not have happened had we still been in the feudal period, because there wouldn't have been any laborers. So having the people disconnected from the land and able to come from the land into the city where the factories were was critical to the Industrial Revolution. So these things kind of tie together. In any event, employment at will historically is a fairly positive thing, both for employees and employers. Now what's interesting for me when I teach this to undergraduates especially is they envision employment at will as a bad thing because they put themselves in the status of the employee, not as the manager. Well, you are all here tonight to be the bosses, not the employees. So employment at will, on theory, gives you the right to fire people and for those people to leave whenever they feel like it. Now we put reasonable rules in it. We say if you want to leave with your vacation, vacation's not required to be paid, we say you must give at least 2 weeks notice in order to get any unused vacation pay. A lot of businesses say if you want to leave and be eligible for rehire, you must give notice, give us a couple weeks. But that's because we're working from the presumption of employment at will. Now before I move on, I want to talk about the confused concept that has no relationship to it, and that is right to work. Right to work is exclusively a union concept. About half of the United States are old line industrial states. In fact, many of the states that have been talked about in the election this fall, Indiana, Ohio, Wisconsin, Michigan, what we sometimes refer to as the Rust Belt. A lot of those states are union states where if a union organizes your business, everybody to work there must belong to the union. Now, the majority of job growth in the United States has happened in states that are right-to-work states. And that includes Texas, Florida, most of your Gulf states, Arizona, up in through the South. Almost all of these states where there's been substantial population growth and industrial growth are right-to-work states. It makes it harder for the union to economically justify union drive because even if they succeed in organizing a business, they may not force the employees to join the union and pay dues. So right to work is a separate concept from employment at will. It is very, very common for the uneducated to confuse those two concepts. None of you are going to do that because you've been here tonight, so please keep that in mind. Okay, let's go back to employment at will. Now, the problem with employment at will is that we have created statutes that give so many people so many different protections that employment at will is somewhat illusory today. So it's still there. Texas and Virginia, 2 states where I practice, are 2 of the best known employment at will states, but you still have to be very, very careful. One simple example, I worked with an air conditioning contractor in Virginia, and they were in big trouble with the state of Virginia for unpaid unemployment taxes because they did not know what they were doing with regard to unemployment. So Billy Bob would get fired for stealing equipment off the truck. He'd apply for unemployment. They wouldn't fight the unemployment. They weren't organized enough to do that. Next thing you know, small business, 18, 20 employees, they got 4 or 5 people pulling unemployment. All of a sudden, they owe the state of Virginia $30,000 in unpaid unemployment claim exposure. So I went and started working with them, and it was like, well, did you understand that each one of those claimants, you've just financed them into business? Because since unemployment is poorly policed, the money that they're getting from unemployment allows them to set up their own air conditioning business, and you're subsidizing it. So not only are you paying the state back for all this unemployment claims that you've had, but you're actually helping these people set up businesses against you. So we had a little attitude adjustment session. I actually had to go in and negotiate with the state to help get them off the hook because it was a lot of money for a small business. But anyway, one of the things we focus on is if you're going to fire people, you want to consider eligibility for unemployment because it costs you a lot of money as a business person. So just on that basis alone, you want to document what you're doing and have a good reason to fire people. Now, does that mean you can't fire somebody just because you feel like it? Theoretically, no. But if the person is a person of color, is female, is disabled, has recently had a health issue, has recently had a workers' comp claim, you're very likely to get sued for any of those reasons rather than the fact that you simply felt like firing the person. So again, employment at will, broad concept, followed by many states, not so exciting in day-to-day reality of what we do as employers. Also, I want to quickly mention California. California has implied contract, which means they are not an employment at will state overtly. It is assumed that if you have been hired, you have an implied contract with the business to continue to be an employee of that business. And so that's called implied contract. California, the leading proponent of implied contract. Most of the other states do not imply the contract. However, I saw litigation in Texas about 20 years ago where the court allowed the person to argue intentional interference with the contractual relationship because the company allegedly interfered with their subsequent employment in an effort to enforce a non-compete agreement. So, pretty interesting situation. And I think I mentioned, if any of you have seen my LinkedIn posting, I was quoted in an article on non-compete agreements for medical doctors in an article that went up recently. So I'm going to do cross-reference for it on my LinkedIn page. So, well, let's talk a little bit about the rest of this. One of the big issues with employment at will right off the top is something that is state by state, and that is what's called the exception to the employment at will doctrine, and this is usually based on good cause. So the classic cases here in Texas is called Sabine Pilots, and what happens is there's a ship up in the General Beaumont area. There's a sailor called Hawk, H-A-U-C-K, and Hawk is ordered by his captain to pump the bilges, and they're sitting again in a canal or a passageway up near Beaumont, Sabine Pass, and he goes up on the deck and he looks out and there's a big billboard-sized sign that says, "Do not pump the bilges here." Against the law, U.S. Coast Guard regulations. So the young sailor Hawk, he goes to the captain and he says, "Wait a minute, I can't pump the bilges. There's a big sign up here that says it's against the law." So the captain fires him. So he gets Provost Humphrey, which is a big pro-union firm up in the Beaumont-Port Arthur area, to represent him, and they win the case, Texas Supreme Court. This was in 1987, and the court says, if you're being ordered to violate a law that can be documented, then that is an exception to the employment at will doctrine. You can't do that. Now, it's a very strict interpretation. Nurse is told to give a medication to a patient, and she says to the doctor, this doesn't sound right. This sounds like too much that could kill the patient. She gets fired. She brings a Sabine Pilots type case. Court said, no, you're not protected because you were not being asked to violate a law. Very narrow exception. You say, oh, but it's okay to kill the patient, but it's not okay to violate a Coast Guard regulation. So you see how tight. I also want to mention, can I practice in Virginia? Virginia does not have the public policy exception to the employment at will doctrine. So again, you need to know what it is state by state. But again, for most of us, I strongly recommend every single termination be treated like a protected individual. Then that way you win the unemployment claim. If there's other administrative claims, then you're going to be successful as an employer. And again, we always teach this from the employer point of view because you're all here to be managers and not peons. Now, we just want to mention quickly, we talked about this already in the agency chapter about independent contractors. Many startup businesses treat everybody like an independent contractor. You don't have to do that ugly thing called wages and withholding, and you don't have to buy workers' comp, everything is lovely. The problem with it is that many people called independent contractors are really employees. And this is significant because if you misclassify someone as an independent contractor and they're really an employee, you may get liability after the fact. So that's something that's very important to be aware of, is that a misclassification could cause the IRS to come in and say, hey, wait a minute, you didn't collect these wages. Well, how do they find out? A lot of independent contractors don't pay their taxes. So they work for you for a year or two, and they owe Uncle Sam $20,000 or whatever. So they go and get audited. Uncle Sam says, well, where's your withholding? And you say, well, I was treated like an independent contractor. Here's my 1099s. And they say, what did you do? How much did you do? Did you work for anybody else? And they go through a list of things readily available as an IRS publication on independent contractors. Basically, we're looking for control. We're looking for how much the person brought to it. We're looking for, did they work for anybody else? And when you look at it, a lot of times, independent contractors make most of their money from just one company. And if they're required to report for work certain hours and do certain things, they slide over the line from independent contractor to employee. And when that happens, the IRS may jump in and say, hey, employer, we'll take that $20,000 plus penalties that you didn't collect from that person. And if that happens, the state will probably jump on that bandwagon and come in and collect unemployment tax on the person. Because if you treat them as an independent contractor, you also don't pay unemployment tax and things like that. So it's very important that you be cautious and understand the distinctions between independent contractors and employees. It's a very significant legal stop there. Now, I just concluded an investigation of the Fair Labor Standards Act. I consulted with one company, settled a lawsuit, and we closed one out with zero liability. We have one going on. So what's Wage Hour about? Wage Hour is about payment of minimum wages and overtime. In the space we have tonight, it's hard for me to go into all the details. The big picture is 1938, we're still struggling through the Great Depression. There's some bad things happening. How many of you read The Grapes of Wrath? Okay, most of you read it in school. Grapes of Wrath, there's a scene in The Grapes of Wrath where people are bidding on pennies per hour to go work in the farm to collect the farm products in California because they've been routed out of Oklahoma. The Okies, as they were called, go to California, and then they stand there. One day the farmer gets everybody he needs for 10 cents an hour. Then the next day he comes back and says, well, who will work for 8 cents an hour? So it's a classic scene in The Grapes of Wrath. So that type of environment brings about a national minimum wage, which I think was 25 cents or 40 cents an hour back when it was passed. Other parts of it are very important also, though. One of the things is it was designed to increase employment. So they said if somebody works more than 40 hours a week, they have to be paid overtime. Well, the purpose of doing that was not to get people more money, it was to increase the sheer number of people at work. Unfortunately, with benefit loads and stuff like that, minimum wage fails to do that today. It failed. Actually, it's cheaper, generally speaking, to work people overtime than it is to add more people in many cases. So it doesn't accomplish that. One of the things it does do, which I think is very admirable, is it puts limits on child labor. Basically, children under 14 basically can do paper routes, work for their parents, or be actors and actresses. Children 16 to 14 can work off school hours. They can work longer in the summer if they're not in school and so forth. And children 16 to 18, on the other hand, can do pretty much what you need them to do, but you need to be very careful, especially with safety-sensitive things. I saw a restaurant have some legal problems because their crew of high school students who were working in a fast food restaurant had access to the meat slicer. Meat slicers are deemed very dangerous, like handling saws or chainsaws or whatever. Just washing the meat slicer, not operating it, washing the meat slicer was found to be a child labor violation for a 16 to 18-year-old. So many businesses today, because of our aggressive child labor laws, don't hire anyone under 18, except maybe for summer fill-in and usually for very light assignments. Now the positive aspect of this, again, you know, get in our time machine and go back to 1938, the Great Depression. We need jobs for adults. What do we do with the kids? Shave. We'll send them to school. So America creates a new class of educated people by implementing child labor laws, because we then send them to school. Most of the United States in 1938, school becomes mandatory through age 16. And of course, we still do that today. Yes, sir?
Can a company not allow you to work overtime?
Yes, and this gets real tricky. I'll tell you where I've seen companies get in trouble in wage hour investigations. They have employee handbook said, you can't work overtime. You work overtime, you won't get paid. That one will get you flagged every time. So usually what it's written is, it says, you need permission to work overtime. But if you work overtime, you have to be paid for the time if you're a non-exempt employee. But what happens though is, if someone works overtime without authority, you can suspend it without pay. You just have to pay them for what they work, and then you can suspend them other days to punish them for working overtime without authority. So most companies have a policy of approving overtime. And like I said, overtime is relatively common in the United States. Interesting thing is, I study international labor law from time to time, is in China they have overtime, but then they have an absolute overtime, and supposedly nobody there works more than 60 hours in a week. Now what's interesting is that they do investigations of Foxconn, which is a Taiwanese company that's the largest private sector employer in China. And they will have people that will just clock out but keep working. You clock out, you keep working in the United States, you have committed a wage hour violation. Walmart has been accused of this on more than one occasion, and they've paid some tens of thousands of dollars where people said, well, yeah, we're told we're paid for all hours of work, all the policies are right, but we've got a store manager who's trying to make budget, and they'll tell people to clock out and keep working. And again, that is against the wage hour laws. It's an interesting area, but that's nationwide. And then keep in mind, many of you work in different states, is that many state laws have been passed. San Francisco, $15 minimum wage. Washington, D.C., federal government, they have a state district minimum wage that's higher than federal minimum wage. How that happens, I don't know, but in any event it does. And so a variety of different local and state rules that may affect what you do. The hot one right now is a required paid sick leave. So several states and several municipalities have passed required paid sick leave. Easy fix, you just reduce vacation to equal, because most employers provide vacation, you just reduce the vacation by the amount of required sick leave, no problem. But it's a stupid rule. And I oppose states getting in the way, because what it does is it hurts businesses that are too small yet to offer paid sick leave. Many small businesses that I work with provide 2 or 3 days of paid sick leave. New rule, I'm trying to remember what state it is. Per year, usually. Yeah, real small. We're talking micro businesses, startup businesses. So, but what happens is I'm trying to think if it's Michigan or the city of Detroit. It's a fairly well-known city. They pass a law, there's no exceptions. If you're in business and you have employees, you have to give them a week of paid sick leave a year. And for tiny businesses, what I call micro businesses, 5 or less employees, that's a killer. I mean, that's, if they're providing any benefits at all, it's all going to go into that one required benefit. And you're going to have to be sick for after vacation days and stuff like that. So it's a dangerous trend, because it doesn't respect the way businesses get started and grow.
So this law applies, like you were saying, to all businesses, no matter how small they are, no matter.
That particular one does, right. In many laws, like the Family Medical Leave Act, which is a federal law, applies 50 or more employees. The mandatory health care coverage under Obamacare is 50 or more employees. Okay, so it's unusual to have a law. The EEO laws, the employment discrimination laws, kick in at 15 or 20 employees. So it's very unusual to have a law that just says everybody's covered. And it's a shame, because the small businesses tend to be where the employment growth is in the United States. So you want to encourage small businesses to start and get up and running. give them a running start before you start beating up on them. It may also encourage them to keep people, again, startup businesses use a lot of independent contractors. It may also encourage them to use employment, call the people independent contractors longer. So then it magnifies a different legal issue. So it would be a pretty interesting situation. Equal Pay Act 1963 said that men and women must be paid the same for the same work. By the way, the motivation to this law was we were in a recession, was to get employers to fire women and hire men. The intent of the law was exactly the opposite to its interpretation today. Because the theory is that since men at that time were considered the only breadwinners, and the economy was struggling and a lot of people were out of work, that if we made women as expensive as men, that they would hire more men. Interesting, yeah. It's something I learned relatively recently. It's backwards to the way people think it is. We mentioned the Family Medical Leave Act. We talked about unemployment. We talked about Affordable Care Act. Okay, worker safety. Worker safety is a big deal. This is one of the few areas as an employer where you can go to jail. If you have a fatality at your workplace and it is established that you ran your workplace with careless indifference to the safety of your workers, especially if you have violated specific provisions of the Occupational Safety and Health Act, that you may be criminally prosecuted if something bad happens, especially if it's a multiple death situation. So, and a lot of times there are circumstances that develop where there were things that could have been done to create a safer workplace. So, very interesting area. Now, one of the areas of confusion is workers' compensation. Workers' compensation is not required in Texas. Texas is one of only 3 states that does not require workers' compensation. Now, the problem with this is that many small businesses in the state of Texas set up and do not operate with workers' comp. But what they don't understand is workers' comp is a no-fault statute that says if you get injured, all you have to do is say, I got injured at work. It could even be your fault, but you got injured at work. You automatically will get, on a no-fault basis, you'll get coverage for your injuries, medical care, and you'll get what are called indemnity payments. That is a replacement for your wages, usually based on 2/3 of your wages before you had the accident. Now, it's not based on your overtime, it's based on your base wage. So it might be appreciably less than you were making if you were working a lot of overtime. But in any event, what happens is that if you do not have workers' comp, you can be sued for everything. And so I call a company running without workers' comp, again in Texas and states that do not require it, a bet the farm proposition, because you could lose everything if you have a substantial claim. And I actually saw this happen. A company that manufactures food products not intentionally had a gap in their workers' comp. The insurance agent got the bill, didn't make sure the company knew about it. There was some kind of follow-up. Anyway, they're in a gap in workers' comp coverage, and a person is badly hurt. And at that point is when I was brought into the case, and I talked to the company, and they didn't have much money. They definitely didn't have the insurance. So that's the first thing you do is, well, it's a workers' comp claim. Nope, didn't have workers' comp. Wasn't my fault. Didn't make any difference. They didn't have workers' comp the day this person got injured. Yes, sir?
Does workers' comp apply to psychological injury?
Yes, but it's much harder to establish. Usually we're looking at psychological, when you think about PTSD. PTSD is a gigantic liability for the Veterans Administration and all that. But here's a good example of how workers' comp doesn't really get the job done. I used to work a lot with convenience stores. Convenience stores tend to operate 24/7. bad things oftentimes happen midnight to 6 a.m. So you have a single female on shift, a robber comes in, steals the money, threatens her with a gun, one case sexually assaulted. Then she's back at work. She's not shot, she's not physically hurt, but psychologically very damaged. Workers' comp does not do good at that. Now, if you don't have workers' comp, that could be a claim for hundreds and hundreds of thousands of dollars. But those are the areas where workers' comp tends to undercompensate for psychological injury. Again, you have to separate that from the military. The VA is paying big time because it's got a lot of people on disability and a lot of people who need psychological help. Some are getting better care than others. And there is a big tendency today, you know, I know, you know, they're running Fraser, the famous psychiatric radio psychiatrist, does a radio show. The reality is the Freudian analysis and all that, not a lot of that happening in that type of fixing people in the VA, unfortunately. It's not what we would hope it would be in terms of coverage for people. So, but an interesting area. Privacy is an issue. One of the things, again, is we teach on a national level. Nationally, there's no particular law of privacy for workers, but on a local basis, there are some states that restrict drugs in the workplace, drug testing. Generally speaking, drug testing is not regarded as a violation of privacy. It's considered part of your right as an employer to maintain a safe workplace. Be cautious with it, however. Massachusetts comes to mind as a state that limits the right of employers to drug tests. So again, it varies from location to location. I think the last I checked, about 5 states restrict drug testing. No such restriction in Texas or Virginia, 2 states where I work, and most of the Gulf Coast and up into the Deep South do not restrict drug testing. But certainly you want to have normal privacy rules. Now, where privacy is very important is medical records. As an employer, it is inevitable, especially if you have a self-insured health insurance plan or you do the processing of claims in-house, you're going to have access to health information. It's extremely important that the health information be protected. Texas actually has a state law on top of the federal law. The federal law is called HIPAA. Most of you have heard about it. The Health Insurance Portability and Accountability Act of 1996, and that provides for portability of health insurance. If you have group health insurance with employer A and you go to employer B, as long as you sign up for the coverage as soon as you can, you have no gap in coverage. You're not required to wait to get into the other employer's plan. That's the portability aspect. The other aspect of it is that it requires a digitization of medical records to make records more easily transferable between hospitals and doctors and so forth. That has been a little less successful. But then the third part is that employee records need to be kept private, hospital records need to be kept private. So several different things. So that's actually a bigger concern within privacy than drug testing. But it's certainly a good idea. Here in Texas, we recommend that all personnel files be secure at all times with limited access by the usually director of human resources or by key personnel. I remember in the old days, I've been doing human resource law for a very long time. Manager wanted to know if somebody had some medical problems, they just walk down to HR, go pull the person's file, go and say, oh yeah, the person's taking this medication for psychological illness. Yeah, I think I'll get rid of him next week. Okay. So that kind of stuff is no longer permitted because, again, files have to be secure, people have to have a reason. Now, can a supervisor gain access to a file? Yes. They usually have to go to the human resource director and say, I need to know if this person's on some type of a medication that affects their performance. They don't appear to be with the program. Something doesn't appear to be okay. I need to know in order to be a better manager. That's most likely going to be a permitted situation. but not just to hand people personnel files, which used to happen. So
What if your information is hacked?
well, interesting question. Suppose your information is hacked. Unfortunately, if you have taken custody of information, it is your responsibility to keep the information secure. So what might happen, and unfortunately it could lead to significant damages, is a determination that you were careless in maintaining employee files, and therefore you helped to create the hack that occurred. And that's a very serious accusation. And this is an area of the law that is still developing, so I don't want to comment beyond that other than to say that if there's a growing body of evidence that says you should be encrypting data that's sensitive. For one thing, it would help with trade secrets and other types of legal and important documents you have. But in the health area, growing information that should be encrypted. And there's encryption is becoming more commercially available. And the latest bar articles that I read for lawyers talks about saying that lawyers everything a lawyer does should be encrypted. They're saying it's now considered what would be the appropriate standard today. And I think if you look into it for larger businesses, certainly it's expected that if they have their personnel records electronically, that those records can be encrypted.
To what extent are lifestyle choices protected by privacy laws? So I'm thinking of Houston Methodist,
Yes.
which I understand does not allow their employees, or at one point did not allow their employees to smoke.
Okay, smoking, okay, lifestyle choice. I thought you were going to say something else about domestic partners. So let me answer the question. I thought you were going to ask me. Okay. Domestic partners, that ship has pretty much sailed, I think, even here at St. Thomas, which actually could come under the Hobby Lobby exception under the Affordable Care Act. I think they're heading in that direction. Certainly distinguishing between gay couples and heterosexual couples, that ship has pretty much sailed nationally. So that lifestyle choice, we don't have to discuss it anymore because it's pretty much been legally decided. Again, with certain exceptions for closely held businesses, religious organizations like the University of St. Thomas. Second part is, in terms of decision to smoke, I've actually had one of my clients wants to, it's a very fast-growing business. They have about 500 employees today, and run by one husband and wife team. And the husband is just like, he's on a rip and tear to get rid of anybody who smokes. Part of it is it will help you with your medical insurance premiums, the fewer smokers that you have. But legally, it's state to state. I think some of the states have determined that you have a right to smoke, which means that you cannot charge differentials. There's been a lot of controversy with the EEOC involved about whether you can discriminate between people that are participating in health programs and people who are not. So it rolls into a whole area. In Texas, it is most likely legal to discriminate against smokers. To say, we do not permit smoking. I'm very anti-smoker. I generally don't recommend that. I recommend that you say, we do not encourage smoking, we do not endorse it, and you control it by the lifestyle. You know, people spend a lot of time at work. No smoking pads, no smoking in the building, no smoking in the bathrooms, no smoking near the front door. You make it so unattractive. And what's happening in the Texas Medical Center is, I remember I had a friend in the hospital about 10 years ago, and I went to visit her in the hospital. It's a huge medical center, and they had a balcony type thing, like an interior area open to the environment, and people were out there smoking. I mean, and someone was rolling their IV carts with them and stuff like that, smoking away, and it was really disgusting. That hospital was one of the pioneers where, and it made sense to me, again, as an anti-smoker. I'm not just a non-smoker, I'm an anti-smoker. Is they banned smoking entirely on the campus of the hospital. So you have to actually leave the entire real estate that the hospital controls in most big medical centers, it's a couple blocks at least, in order to go smoke. That makes it hard to continue to be a smoker, but at the Texas Medical Center, what's happened is the same thing's happened, where they've defined it kind of mutually is the entire campus. Now, one of the problems is my better half works at Memorial Hermann on the weekends, which is right on the edge of the medical center, so the people there can get out to the sidewalk on the perimeter of the medical center, arguably not part of the medical center. So they can get off the campus, if you will, to a smoking zone. It's pretty disgusting to see them out there in the hospital gowns with their IV pole walking out to the sidewalk at like Fannin and Cambridge to get off the campus enough to go smoke. But it's a pretty crazy deal. My favorite story, a dear friend of mine, and he has passed, probably helped along by his smoking. He and I were friends for 30 years, and he passed away about 2 years ago, and had a lot of medical problems, like kidney cancer, COPD, lung cancer. But what he did, he worked for a company that had a no smoking campus, and what he would do is, as soon as he got in his car at night, he would smoke himself literally to death from his work to his home, where his wife did not permit him to smoke either. But he made up for it in that he got about a half hour, 40-minute commute. And I don't know how many cigarettes he smoked, but I can tell you, I think that car had to be just crushed after he was done with it. But it was interesting. But yeah, so unfortunately it's hard through workplace control, but most people, cigarettes work about every 20 minutes. Most people are heavily addicted need to smoke a cigarette every 20 minutes. So if they can go 10 hours without smoking, hopefully they'll stop smoking, but not guaranteed. Yes, sir?
A doctor's office I used to work with, of course, they got their computer system hacked from people over in India.
Yes.
And of course they all have all patient files and everything. And people sent a ransom via email
Oh, yes.
to get a computer system back. Who is liable if that information goes out? Is it the computer company, or is it the doctor's office?
Unfortunately, it's going to be the doctor's office, and their defense is going to have to be that they encrypted the data and they did the best they could, and they're probably still going to have an exposure. By the way, the headline on our screens here, in fact, I changed the screen in order to save time, but the screen here says a ransomware notice on our screens here at the university. So ransomware is definitely a big deal. A lot of law firms and businesses have been attacked in that fashion, where they can't get it back, and it's very, very expensive to unhack the hack. Usually they can't go long enough to unhack the hack. They end up paying the ransom in order to get back on board more quickly. But I would say that the responsibility is unfortunately going to be the medical practice. I had a case a good 5 years ago now, still a client of mine, where they had a break-in in their offices, and it appeared to be an inside job, like a former supervisor or somebody like that. They never pinned it on anybody, but somebody came in and took all of their CPUs, the computing units of the computers. One of those computers contained all of their plans and things for their company. Another computer contained all of their employee records, including social security numbers. So the company, I work with the company on that, purchased a identity theft package for every single employee that they could locate or that had recently been there, whose data might have been in that computer. So they did the best they could to try and provide it. Best I can tell, and again, I still work with that company, nothing ever came of it, which again supports the fact that it was an inside deal. The guy wasn't doing it in order to get employee records, he was doing it to get to the company plans. He just didn't know which computer had it, so he just took all the computers, and we don't know what he did with them. Eventually, he probably made sure that they were disposed of in such a way that it never came back to him. So he probably destroyed the hard drives and did other interesting things with the computers. But the company basically lucked out because it wasn't somebody attempting to hack the employee data. data, best we can tell at this point. It's been 5 years or more since that happened. But again, encryption, unfortunately, is going to become the standard, and as encryption improves, you're going to be expected, again, in proportion to the size of your business. You got 4 or 5 employees and you're running a dry cleaners, we're probably not going to expect you to be too encrypted. If you're a sophisticated medical practice, we're going to expect you to be the best encryption, and it's going to vary from there to there. And big companies like a Shell Oil, ExxonMobil, they're going to be expected to be encrypted. So again, it's going to vary. We're going to have to see those standards change. I wanted to mention GINA, Genetic Information Non-Discrimination Act. This is a law that was passed without a need. There is a marginal opportunity to pre-test people for genetic predisposition. It is rarely used in employment because about the only place it would be relevant are chemical plants and places where there's some marginal exposures to some bad stuff, and some people might have more likelihood of getting sick than somebody else. And so in 2008, Congress passed GINA saying you can't force employees to be genetically tested to screen them out. It's an interesting law, but I don't think it was a big risk at the time or to even today. We want to talk briefly about labor law. We've already touched on unions. Most of you are familiar with unions in the United States because it's part of American history. The unions mirror the Industrial Revolution. Again, 1776, Industrial Revolution hits in England, coincidentally with the Declaration of Independence here, and Wealth of Nations being published by Adam Smith in England. About 100 and some years later, post-Civil War, we have the Industrial Revolution in the United States, and with industrialization, we have unions. We had the Knights of Labor, we had the American Federation of Labor, starts back then, Samuel Gompers very famously. The union peak is in the late 30s, again part of the Great Depression, and the 1935 National Labor Relations Act is passed that guarantees employees the rights to organize. And what happens is overnight almost, 1935, 1938, 1939, the steel industry becomes almost 100% unionized. The automotive industry, almost 100% unionized. So several industries, almost overnight, become almost completely unionized. By the mid-1950s, we are at the peak of unionization and power of the unions, where it's a very substantial percentage of our entire industrial workforce. Following that, we began to have a real shift in the way we did business. Main difference was services. Services historically were not unionized. There's more growth in unionization of services today, but again, there was a big gap in there. Private sector unionization today down to about 9%. Where the growth has come, because the total is up about 13%, is many federal employees are covered by union contracts. So federal and state, you may know, the city of Philadelphia's got a strike going on. SEPTA, Southeastern Pennsylvania Transit Association, is on strike, and the Pennsylvania teachers were on strike last week and stuff like that. This is all where the growth is. It's not in the private sector. Now, there's still substantial areas. The transportation is still substantially unionized in the United States. The oil patch, which we're near the refineries, most of the big refineries along the ship channel in the greater Houston area, Pasadena, and Deer Park, most of that industry is unionized. Also down on the docks, a lot of that activity is controlled by the harbor workers union and stuff like that. So certain industries very heavily unionized, but again, does not constitute a major percentage. However, as managers, you need to be sensitive to the fact that you want your employees to feel that they're well treated, so they don't decide that having a union is a good idea. And so some of the things to be aware of there is, again, the Norris LaGuardia Act permits the strikes, then we had the National Labor Relations Act, also referred to as the Wagner Act. Created the National Labor Relations Board. One of the oddities of the NLRB is it is not part of the U.S. Department of Labor. It is a completely separate agency, which of course for us taxpayers means we double up on the overhead for no apparent reason. But in any event, it's separate from the Department of Labor. 1947, what happens is that during World War II, wages are frozen. We created a state agency, a government agency that controls wages. And so the unions couldn't strike and the unions couldn't argue for wages. The unions struck anyways. Peak year was 1946 when all restrictions were off. Following World War II, we have a record number of strikes. Industry is crippled across the United States. It's a particularly painful time because nobody's been able to buy a new car for 4.5 years. After Pearl Harbor, every bit of industrial production in the United States goes to making war. And we were awfully, awfully good at making stuff. I mean, we'd make planes in hours. We'd make tanks in a matter of a couple of days. I mean, we produced the most extraordinary amount of materials for the war effort for the entire world because we were still up and running despite Pearl Harbor, whereas England was basically shut down, France was occupied, most of the rest of Europe was occupied. Where were you going to make the stuff? It was made in the United States by just an absolutely incredible effort. But when we came out of that effort, people were ready to buy cars, buy homes, they needed appliances for those homes and so forth. So as a result of that, what happened was the unions went on a record number of strikes, crippling America's recovery from World War II. And as a result of that, Congress, over President Truman's veto, by the way, Congress passed the Taft-Hartley Reform Act, which basically said the employers had some rights too. The National Labor Relations Act was strictly one-sided. It was all pro-union. There was no balancing act. So Taft-Hartley attempted to put some of that back to create some balance. Didn't quite get there. However, we passed another law, the Labor Management Relations Act in the late 1950s because of union corruption. Most of you have heard the name Jimmy Hoffa. His arch rival was Robert Kennedy, brother of course, assassinated John Kennedy, the president. And this is before Jack Kennedy becomes president. Is Robert Kennedy is over in the Department of Justice. The only family situation that ever occurred is once Kennedy becomes president, he names his brother as Attorney General. So, and I think there's a law now that would prevent that from happening, from appointing one of your siblings to one of the most important offices in the United States. In any event, Robert Kennedy just had a ripping tear for Jimmy Hoffa, and eventually they get Hoffa, I think it was on tax evasion, something like that. They did get Hoffa on being a gangster. They got him on that. And so in any event, many of you are familiar with the fact Hoffa goes to federal penitentiary. He's in for a mere period, probably about 5 or 6 years, and then he gets pardoned, goes home, and magically disappears. So we don't know if he's living on some island. He's probably deceased now either way, but most common assumption is that he was assassinated by other bad guys because they were afraid that he got released in exchange for agreeing to give testimony against other bad guys, and they decided to remove him as a witness. So pretty interesting story. Again, I don't have any inside information. Yes, sir?
I think you're buried under the
Oh, they have dug up so many cornerstones and x-rayed cornerstones looking for him. So I don't get too involved now. Personally, I do believe he was murdered, and I don't know where he's buried, but I know they get all sorts of tips over a long period of time, and I don't know what the true story is, but I find it an interesting thing. He wasn't, based on what I saw, I remember watching some of the televised, they actually for entertainment back then there wasn't cable, so part of the daytime entertainment in the United States was watching live broadcasts of Kennedy and the Kefauver Commission asking Jimmy Hoffa questions on live television. That's actually part of the daytime entertainment. You could watch as the world turns, or you could watch the Kefauver hearing. But it's a very interesting time period for that. So there's been, and then again, as that period hits, it's when you start seeing the unions really take a change again. Part of it is that we pass more and more laws that supplant what unions would get for people. If you can get it without a union, why have a union? So that was one of the drivers. The other driver was the fact that we changed as a country, where we emphasize more on services which are harder to organize, more professional workers who are less likely to organize. So it's an interesting time period. I want to touch on just a couple key slides. Yes, sir, go ahead.
Just a question. I guess that you mentioned that the law was passed against the president's veto.
Over the president's veto. So in other words, President Truman, normally a law goes through both houses of Congress. It goes to the president to sign. It's very interesting to me because the unions really hurt Truman. Now, he did get reelected in 1948. Remember, he takes over from Roosevelt. Roosevelt dies in office only 4 months into his fourth term. So Truman has virtually a full term before he stands for election in 1948. But he almost doesn't get reelected because of the big union strikes and stuff like that. But for some reason, he still felt like he really needed the union's support in order to get reelected in 48. So he vetoes the Taft-Hartley Act, and then both houses of Congress override his veto. So a lot of times when you hear that in the news today about Congress passing a law, is whether it's a veto-proof majority or not. Do they have enough? And I think it takes 2/3 of both houses of Congress to override a presidential veto. So in that case, that meant both Democratic and Republican senators and congressmen voted against Truman in terms of passing that law. But it was interesting because as Truman, because the economy took such a horrible hit because of all the strikes, I would have not been a big fan of the unions myself. But again, I don't know the whole story behind that. I've done a lot of research on it, but that's about all I can tell you. National Labor Relations Board, again, is independent Department of Labor. 5-member board, tends to follow who's the party in the presidency. So they serve a staggered term. Usually it's 3-2. 3 Democrats and 3 Republicans during a Democrat president, and then vice versa during a Republican president. So it tends to swing both directions. In order to have a vote for a union, you need to have 30% of the workers indicate an interest in election. As a practical matter, this does not happen today because the unions don't want to waste resources having a losing election. The unions are very selective today. When they have an election, they tend to win them. So your objective as a manager is not to get to an election because your odds are not as good if you've gotten to that point, because that usually means they have won 50% of the cards. What they do is they'll hang out near a factory or refinery, and they'll hang out at the ice houses and bars where employees congregate after work, and they'll try and find plants to go into people working in different factories to try and unionize them. A lot of unionization effort is in services. One of the things you may not realize here in Houston, downtown Houston, many of the high-rises, the janitorial companies that service the big high-rises, many of those are now unionized. And that's happened over the last few years. And it's kind of interesting because there's got to be a lot of non-union competition in that area. So I don't know that people can get big raises because it's a very price competitive industry. But just a little bit about what's happening there. So again, 30% is the minimum. If the union wins the vote, they get to negotiate for a collective bargaining agreement. We call that a CBA. And a couple other things we wanted to mention in regard to this is that management needs to negotiate in good faith if the union wins an election. It doesn't mean they have to reach an agreement. It doesn't mean they have to replace wages. Over the last 15 years, I've had 2 clients lose union elections. In both cases, the clients never ended up with a CBA. In one case, the union never showed up to negotiate. In the other case, the union showed up, had 1 meeting. My people were very respectful. They said, well, we'll be glad to discuss this with the owners of the company and so forth. They never came back for a second meeting. And after a year, it goes away. So they want to come back a year later, they have to have another election, and it never happened in the company. So It's not a simple process. Again, usually they're running the numbers to say, are there enough people potentially in the bargaining unit that it makes it worthwhile for us to use the effort over there. So it's a pretty interesting situation, but it's still not good for you as a manager if your workforce gets unionized while you're the boss. Most of you are familiar with the strike. This means people stop working. There's two types of strikes. You need to know the difference. There's three of them on the screen here. An economic strike is a routine strike. Hey, that's what you see in Philadelphia. The transit workers want more money. It's an economic strike. Under federal law, you can permanently replace economic strikers. The second type is called an unfair labor practice strike, or ULP, and that means that you allege that the company has violated your CBA, your collective bargaining agreement. You cannot permanently replace those strikers, ULP strikers, so you need to be cautious about that. And then number three, employer side of the strike is the lockout. Of course, the probably most famous lockout was the big NFL lockout. Gosh, what is that, 20 years ago now. There's a movie about it called The Replacements that talks about how the NFL football players went in and they hired college players and stuff and tried to finish the season.
Referees.
What's that?
The replacement referees.
Oh yeah, the whole thing was, that's a separate strike. But a lot of these things turn into a real mess because you're missing the professionals. A lot of unionization in Hollywood, many of you are aware of that. Many of what you may not be aware of is many TV shows are shot in other places today. Many years ago, they were all done on sound stages in Hollywood. Today, many of them are done elsewhere, including Canada, because of the cost of labor, the cost of site operation, and unionization. So because of the mobility that's there, a lot of these things happen a little bit differently than you think. So pretty interesting. But anyway, lockouts, the employer side of a strike.